welcome to Disputes and Perspective. I'm Doug Cherry, a partner in the disputes team at Reed Smith. This podcast series will discuss disputes-related trends, hot topics and developments occurring in the global legal landscape, and hopefully provide you with some helpful insights and practical tips. If you have any questions about any of the episodes, please feel free to contact our speakers.
Bonjour à tous. Welcome to this new episode of Disputes in Perspective. Today's theme is criminal liability in merger absorption in France. I am Daniel Cadar. I'm a partner in the dispute resolution team at Reed Smith in our Paris office. I'm happy to be here today with Pierre Fischer, who is a senior associate in our team.
Thank you, Daniel, and thanks everybody for joining us today in this podcast.
We would like today to discuss the landmark decision handed down on November the 25th, 2020 by the criminal division of the French Cour de Cassation, which is the French Supreme Court. This decision is important because it's a milestone, a decision that redefined the regime of criminal liability in the event of a merger. While it had previously refused to hold criminally liable absorbing companies for offenses committed by the absorbed company prior to the merger by absorption, the Cour de Cassation decided to radically overturn its case law.
Let's talk about the origins of this new case law, and let's then explain why it's a big change for legal entities in France.
Yes, so far the criminal court had a very strict interpretation of the personal criminal liability. The rules are in the French criminal code, the rule and the principle being no one is criminally responsible except for his or her own actions. And the French criminal procedure code states that the death of the accused person is a case of extinction of the public prosecution without further clarification. And as you can by yourself guess, the basis of the origin is in this case law here. Adapted to company life, since the absorbed company is dissolved at the end of the merger by absorption, the French Cour de Cassation had associated this situation of the deceased individual with that of the dissolved company. As a result, the public action against the absorbed company had to be extinguished.
So, Daniel, you mean that as long as a company merged with another one, there was no means to prosecute it anymore?
Exactly. However, the position of the criminal division of the Cour de Cassation seemed to be isolated from that of other divisions of the same court. So we have three civil divisions, we have one commercial, and we have one criminal one. And the commercial division of the Cour de Cassation had in particular taken another stance, as well as other jurisdictions, the Court of Justice of the European Union, the CJEU, and the European Court of Human Rights.
But that was before this case. So what happened in November 2020? In the November 2020 case, a company committed a breach of security consisting of the involuntary destruction by fire of a third-party good. The judicial investigation lasted for almost 15 years before the company was summoned to appear before a criminal court. However, shortly before the hearing, the company took part to a merger and was absorbed into another organization. The victims then summoned the absorbing company, requesting the merger to be declared unenforceable for fraud. They suspected that both companies set up a merger only to avoid criminal prosecution. And the French Supreme Court ordered additional information to determine whether the merger had been fraudulent. The absorbing company challenged this judgment and went until before the French Supreme Court. And guess what? Instead of ruling only on the question of fraud, the Cour de Cassation went further in its reasoning by ruling on the question of transfer of criminal liability in the event of a merger.
So we had here not a response in a particular case, but a response in principle in the case of absorption. And this is how the French Cour de Cassation overturned its case law. The French Supreme Court set forth that the transfer of criminal liability to the absorbing company can be admitted under 4 conditions. The first one being that only public limited liability companies, so Société Anonyme, SA, or simplified joint stock companies, SAS, are concerned. The second condition is that the merger must have resulted in the dissolution of the absorbed company. Third condition is that only financial penalties are incurred, which means a fine or confiscation. All other types of penalties, such as exclusion or debarment from public tenders, prohibition of receiving any public aid, prohibition of issuing checks, etc., are not applicable sanctions. This case law, and this is the fourth condition, only applies to mergers that occurred after November the 25th, 2020. Note that fraud is a limit to the application of this new solution. If the merger was carried out solely with the aim of shielding the absorbed company from criminal liability, the conditions laid down by the French Supreme Court will not apply, and the absorbing company can be prosecuted anyway, and any kind of penalty is incurred. Would you say, Pierre, that this decision is surprising?
Definitely not. It was totally expected. Actually, the French Cour de Cassation recognized itself that its former approach was totally disconnected from economic reality and allowed the company to escape the consequences of the offenses it committed by voluntarily restructuring itself. This approach did not take into account the specific characteristics of a legal person in comparison with individuals, as a legal person can change its legal form while ensuring economic and functional continuity of its activity. So the former regime, albeit legally grounded, did not really make sense. This is a big change that companies will have to face and anticipate.
Definitely anticipate. As part of the insights or tips on the behavior companies will need to have, the French anti-corruption agency, the AFA, which starts to be broadly recognized, published a guide on the beginning of January 2020 that contains valuable recommendations for all absorbing companies involved in mergers. First, a high degree of accuracy in asset and liability guarantees will be required. Second, the absorbing company will have to carry out a very thorough audit in order to assess the criminal risk that may be passed on to it, both by the absorbed company, but also by companies that the latter may have absorbed through previous transactions. In practice, audits should focus particularly on a series of the following events, like the target company's internal documentation, for instance, disciplinary sanctions, customer complaints, proceedings conducted by administrative and judicial authorities, the target company's ownership and shareholding, the main anti-corruption mechanism implemented by the target company, the wording of any existing representation and warranties, RIPs and warranties, provisions in the deal, the financial and strategic purposes of the operation. The audit should focus on the entire period of activity of the absorbed company that is not covered by the prescription.
And note that in the case of hidden or concealed offenses, the limitation period starts to run on the day the offense is discovered, and not on the day it is committed, which means that the limitation period may well start to run well after the merger.
This is an important point. It's not the date of the merger that matters, it's the date when the offense is discovered that matters. Finally, this audit phase is also crucial as the Cour de Cassation issued another important decision the day after this landmark decision. It was November 26, 2020, concerning the extent of the absorbing company's insurance coverage with respect to the debts of the absorbed company. The liability insurance of the absorbing company taken out before the merger is only intended to cover the liability insurance of the absorbing company taken out before the merger is only intended to cover the liability of the insured company alone, to the exclusion of any other company, even if the insured company subsequently absorbs it unless otherwise stipulated. This solution therefore amplifies the economic consequences of the decision of the French Supreme Court of November 25th, 2020 for the absorbing company.
And this shows that merger discussions will need to include a thorough criminal liability review. Thank you, Daniel, and thank you, everybody.
Thank you, Pierre Serol, and hope to see you soon. Bye-bye.
Disputes in Perspective is a Reed Smith production. Our producer is Ali McArdle. For more information about Reed Smith's litigation and dispute resolution practice, please email disputesinperspective@reedsmith.com. You can find our podcast on Spotify, Apple, Google, Stitcher, and reedsmith.com, and our social media accounts at Reed Smith LLP on LinkedIn, Facebook, and Twitter.
This podcast is provided for educational purposes. It does not constitute legal advice and is not intended to establish an attorney-client relationship, nor is it intended to suggest or establish standards of care applicable to particular lawyers in any given situation. Prior results do not guarantee a similar outcome. All rights reserved.